Good afternoon, everyone. I want to welcome you to the afternoon session of our conference today, and thank you so much for joining us. I'm Kellye Testy, and I currently serve as the President and CEO of the Law School Admission Council. It's been our honor to be able to co-host this with the AALS and the ABA, and I want to give a special shout out to Judy Areen and also to Erwin Chemerinsky, Vince Rougeau, and Darby Dickerson, all of whom were instrumental in the organization of this conference. LSAC was particularly thrilled to be able to be involved because, as you know, we're always out on the front lines building the future of our profession. And so to keep law, to keep democracy strong, those must happen so that we can continue with enthusiasm to help young people find their way to joining our profession. I really am delighted to be here as well personally, because before serving as LSAC's president, I had the honor of being the president of the Association of American Law Schools in 2016. And during that time, I guess it would have been as early as 2015, I chose as my theme the topic, Why Law Matters, and urged us all to realize how critical law is for the functioning and the flourishing of our world. And I pointed out then that I'd always been frustrated as the dean that sometimes it seems hard to get people to realize how important law is. And I just will share one sentence from the annual address I gave back in 2016 that noted that law can be like the air we breathe, perhaps noticed more by its absence than its presence, but we can no more live healthy lives without the rule of law in this world than we can live without air. And waiting to appreciate its vital role until we're choking and gasping is not a good strategy. It's surely not. And in the time between 16 and now, we've seen in way too many contexts how much we need to take care of law and democracy, from the murder of George Floyd to the insurrection in the Capitol, to the challenges to the basic right of voting in our world, to COVID and all the disproportionate effects it's had on BIPOC communities. So it is wonderful to see all of us coming together to focus on rebuilding law and democracy. And I'm very delighted today to introduce the panel on race and voting rights. And in doing so, to turn it over to our moderator. Heather Gerken is the Dean and Saul and Lillian Goldman Professor at Yale Law School, and she will serve as our moderator for this session today. As you all know, she's not only a fabulous dean, but a wonderful scholar in this field in her own right. And so with that, I want to say thanks to each of the panelists for being with us today. I'm so glad you're here. And Heather, it's an honor to turn it over to you, and thanks for being with us.
Thanks so much, Kellye, and thanks to everyone for organizing this just sensational conference. I know we couldn't have a more important topic than the one on this panel, and we just have a group of rock stars who've been devoted most of their career to working on these issues. So I'm going to introduce them very briefly because their CVs are long and distinguished, so I'll just do it by title. We have Bertrall Ross, who's the Chancellor's Professor of Law at Berkeley, Ellen Katz, who's the Robert Aigler Chair at University of Michigan, Franita Tolson, who is the Vice Dean of Academic Affairs at USC, and Kent Greenfield, who is the Dean's Distinguished Scholar at Boston College. They are an extraordinary group of people. We're going to hear from each of them for a few minutes talking about what they see as some of the most important issues on the horizon. Then I'll ask a few questions and then invite the audience to take part. So with that, we'll start with Professor Ross.
Thank you, Dean Gerken, and thank you all for being here with us today, and thanks to my co-panelists for allowing me to participate on this panel with all of you. So we're getting close to the new round of redistricting in 2022. And although the 2020 election gave Democrats control of the White House and 2 houses of Congress, Republicans maintain control of most state legislatures responsible for drawing congressional and state legislative district lines. This round of redistricting will be the first one after the Supreme Court's decision in Rucho v. Common Cause, which declared partisan gerrymandering to be non-justiciable. Now, what I want to argue in my brief opening remarks is that partisan gerrymandering is not only a threat to fair partisan representation in the political process, it is now a threat to the multiracial democratic project. To understand the threat to the multiracial democratic project, we need to return to the early 1990s racial gerrymandering case of Shaw v. Reno. In that case, the Supreme Court properly diagnosed a potential districting threat to America's multiracial democratic project, but identified the wrong source of that threat. It is only now that we can start to attribute the districting threat to the multiracial democratic project to the right source. In Shaw v. Reno, decided in 1993, the court addressed a challenge by white voters to the state legislature's use of race to draw majority-minority districts to provide racial minorities with the opportunity to elect candidates of their choice. North Carolina did not draw these majority-minority districts on its own. Rather, it did so in response to the United States Department of Justice's enforcement of Section 5 of the Voting Rights Act. That act, as enforced in the early 1990s, required that covered states, mostly states in the South, provide racial minorities with an equal opportunity to elect candidates of their choice. This meant drawing a proportionate number of majority-minority districts. The white challengers pointed to the unusual shape of the districts and the Department of Justice's demand that North Carolina draw these districts as support for their claim that the district line drawing violated the Equal Protection Clause. Core to the challenge was the claim that the government impermissibly considered race in the drawing of the majority-minority districts, and the court ultimately agreed. Focusing on the shape of one of the districts, the court explained, in some exceptional cases, a reapportionment plan may be so highly irregular that on its face, it rationally cannot be understood as anything other than an effort to segregate voters on the basis of race. As support for its conclusion, the court in Shaw diagnosed 4 race-based democratic harms that it said arose from the consideration of race in the drawing of district lines. Here I want to focus on the last and what I consider the most important of the harms. The court announced, when a district obviously is created to effectuate the perceived common interests of one racial group, elected officials are more likely to believe that their primary obligation is to represent only the members of that group rather than their constituency as a whole. I label this harm the racial representation neglect harm. This, the court concluded, is altogether antithetical to our system of representative democracy. Now, as applied to a state's drawing of majority-minority districts, there are 3 problems associated with this account of the harm. First, it just lacks empirical support. Although there is evidence suggesting that minority representatives from majority-minority districts do better represent racial minority interests than their white counterparts, there is no evidence suggesting that minority representatives neglect their white constituents. In fact, and this goes to the second problem with this account of the harm, it would be entirely irrational for minority representatives to neglect white voters in their representation. Legislators are part of a multi-member body that makes decisions according to majority or supermajority voting rules. As a result, in order for minority representatives to advance their policy goals, they necessarily have to build coalition with members of the white legislative majority. Recognizing this, it would be entirely irrational for minority legislators to neglect the interests of their white constituents, as this would impede their ability to build the necessary cross-racial coalitions to advance their policy goals. Furthermore, and a third problem, due to the racial wealth gap, minority candidates and representatives for office are reliant on white campaign contributors and spenders. They therefore literally cannot afford to have a reputation of neglecting the interests of white constituents. The multiracial democratic harm from the consideration of race to draw majority-minority districts are therefore imaginary at best. And the benefits from the state's consideration of race in the drawing of district lines, which includes increasing minority representation and voice in the political process, seems to far outweigh these imaginary harms. The court in Shaw v. Reno, however, did diagnose a real threat from the consideration of race in the drawing of district lines. It just identified the wrong source. And the right source for this harm diagnosis is now coming into view. That source arises from Republicans' use of race to pack minority voters and draw the maximum number of majority white districts to advance partisan gerrymandering. To understand why this source produces the racial representation harm identified in Shaw, it's necessary to provide just a little bit of background. For a while now, the Republican Party has been mostly a white party. In 2018, the Pew Research Center found that 83% of Republican voters were white as compared to 60% of the US population. In Congress, 91.4% of Republicans in the House of Representatives and 94% of senators are white. In districts where at least 3/4 of residents were non-Hispanic white, 82% elected a Republican representative in 2018. In contrast, 83% of the nation's most diverse districts elected a Democrat into the House of Representatives. Since the realignment of the parties in the 1960s, the Republican Party has always been the party that appeals more to white voters. But the whiteness of the Republican Party may have different consequences for districting in the coming redistricting cycle due to the rise of white identity politics. In a recently published book titled White Identity Politics, Ashley Jardina finds an increasing embrace of a racialized political identity among white Americans. Whereas the race of white people has historically been treated as invisible, it has become much more visible in the present. This white racial solidarity is not principally grounded in white supremacy and outgroup prejudice, although that is part of the story for parts of the white population. Instead, the primary motivation Jardina finds behind white racial solidarity is a concern among some whites about their in-group and a desire to protect white racial status in a demographically changing country. The rise of white identity politics is important because a majority of the Congress members in the House of Representatives in 2010, 2012, and 2014 were Republicans from majority white districts. And what is concerning about this racial partisan dynamic from the perspective of the American multiracial democratic project is that in an era of white identity politics, it is becoming rational for white Republicans to focus exclusively on advancing white interests at the expense of their minority constituents. Republicans from majority white districts simply do not need to participate in cross-racial legislative coalitions to advance their policy goals, and they can rely exclusively on their white donor class to be financially viable in elections. So what this all means is that in the short term, at least, there are rational electoral incentives for white Republican representatives from majority white and partisan gerrymandered districts to stoke racial divisions and govern as a white man's party. So while much of the focus on partisan gerrymandering has been on how it undermines the fair representation of parties and legislative bodies, we should not ignore the more ominous threat that it poses. And this threat has two related components. The first is a recent activation and encouragement of white racial identity and solidarity by Republicans who stand to benefit politically as a result of racialized partisan gerrymandering. And second, the promotion of racial white identity politics to create and reinforce perceptions that minority democratic gains are a threat to white racial status. As a result of these two components, white identity voters will be inclined to support white representatives who seek to advance white interests at the expense of minorities. Putting this all together, the threat to the multiracial democratic project from growing white racial solidarity and racialized partisan gerrymandering starts to become clearer. Despite all of the criticism, the court in Shaw v. Reno actually proved quite prescient in diagnosing the harm from gerrymandering. The problem is that the court targeted the wrong source. And now that we have a sense of the right source of the threat to the multiracial democratic project, the question is whether Congress or the court will do anything about it. Congress can do something about it by establishing independent redistricting commissions responsible for drawing congressional districts in every state. That would provide critical legal protections for the multiracial democratic project. And if Congress fails, the courts can step in to police the sources of racial representation neglect that are likely to be associated with Republican partisan gerrymandering over the next decade. Thanks so much.
Thank you so much. And now, we have Professor Katz.
So hello, sorry, let me just come on in. It's so nice to be here, and thank you to Kellye and to Heather, to LSAC, AALS, for convening this event. It's really wonderful to be part of this panel, this symposium with so many dear old friends and colleagues, and I'm really looking forward to seeing all of you in person, I hope before too long. The thesis of my talk, my paper, is pretty straightforward, and it's as much about the right to vote and sort of placed on this panel in that spirit. That much of the 2020 election litigation, and particularly the cases involving the rules for the casting and counting of absentee ballots, rested on a decidedly narrow conception of the right to vote. And this narrow conception confirms what I'll argue is the completion of an evolutionary process that began, and we can discuss the date, 13 years ago, 20 years ago, a series of cases that methodically circumscribed the right to vote, supplanting an older version with a new, very narrow version of what voting is. And I'm going to describe this contrast by borrowing from equality law and presenting this idea that what we are currently experiencing and what's the product of this evolution is a formal right to vote, a bare legal right to participate that has supplanted an earlier, far more robust vision, what I'll call a substantive vision of the right to vote that rested on the meaningful ability to cast a ballot on equal terms with other voters. That present law, that federal courts in particular endorse this formal conception, and it explains why they were so unmoved and wholly unpersuaded by allegations during the last election cycle of from dissenting justices, from the media, from the public, from academics about disenfranchisement. So long as the formal right to vote remained, the view was there was no disenfranchisement, even if voters were denied what I would describe as this substantive right to vote. So I'll sort of develop this point briefly by bringing you back to 13 months ago, give or take, in a photograph that you may remember seeing. And it was this was the Wisconsin primary held on April 7th, 2020. And it was a photograph of a woman named Jennifer Taft. And you may remember seeing it. It was cold in Wisconsin that day, and she's wearing a sweatshirt and a hood and a vest, and she's a mask, which at the time still looked quite unfamiliar to many of us. And she's holding a sign made out of a cardboard box in which she's written, "This is ridiculous." And her sign referenced a Supreme Court order that was handed down a few hours earlier that tossed out a federal court, lower court ruling that would have given voters in Wisconsin more time to cast absentee ballots. The voters who had requested those ballots had not received them due to a backlog. And instead, voters like Taft had to brave the polls or decide not to vote. And she told a reporter when the photograph was taken, "I'm disgusted. I requested an absentee ballot almost 3 weeks ago and never got it. I have a father dying from lung disease and I have to risk my life and his just to exercise my right to vote." And Taft's outrage was widely shared by other voters in Wisconsin, by the media, by commentators. And the Wisconsin primary itself was described as a fiasco, a tragedy, a debacle. And much of the blame, a lot of parties were responsible. Many targeted the Wisconsin legislature, which could have postponed the election or run it entirely by mail. There was criticism of the Wisconsin Supreme Court, which set aside the governor's order to delay or to run the election by mail. But a lot of the ire was directed at the Supreme Court as being distinctly culpable for throwing out this district court order that would have revised the deadline for processing absentee ballots. And in so doing, the Supreme Court forced voters like Taft to make this what seemed to many of us to be an untenable choice, to risk their physical safety or decline to vote. And one of the things that I think is so interesting about the opinion was the court's vehement denial that it was at all responsible for any of the difficulties voters like Taft were facing. It's an unsigned per curiam, insisting that it's a narrow technical ruling. The district court intervened where it should not have, and the Supreme Court was simply fixing that error. And along the way, the per curiam repeatedly notes that we're not assessing the wisdom of what Wisconsin's up to here. We're not saying that modifications shouldn't be made to election procedures in light of this emerging global pandemic. And the court says, we can't stress it enough that whatever's happening in Wisconsin, however unfortunate it might be, it's not something, it's something Wisconsin officials can fix. It's not something that the federal courts are there to fix. And I bring up this small rushed per curiam to frame my remarks because I think it captured what were salient features of many of the federal court orders that followed. There's a lot of litigation, as you all well know, in connection with the election. Leading up to it, I'm going to put to one side the post-election litigation for present purposes. And in the course of that litigation, much of it, not exclusively, but much of it was about the rules for casting absentee ballots. Who's eligible to cast them, how they should be cast, what type of assistance folks should get in casting them, and specifically how they should be counted, which was an issue that gained traction as the general election got closer and there was concerns about whether this was going to all come down to one state and possibly to ballots received after Election Day. And in the course of all of this litigation, federal courts threw out most of the challenges. And specifically to changes that were made to electoral rules in response to the pandemic, when those changes were made by a federal court at a moment that was a lower federal court too close or perceived to be too close to Election Day, the so-called Purcell doctrine, and the other line of cases that we saw in the general by a federal court or by some state actor, and under some views, even a state Supreme Court, that were thought to usurp the power of the state legislature under Article 2 of the Constitution, the so-called Bush versus Gore concurrence issue, and a variation of which we've seen in connection with challenges to independent redistricting commissions under Article 1. The notion that the Article 2, for the Article 2 purposes, that the legislature decides how the electors should be selected. And what links all of these cases and what I'm focusing on in my paper and what I think is worth our attention is a larger point. That whether these decisions are saying we're too close to the election day, whether these decisions are saying we're infringing or possibly infringing with the power of the legislature, underlying all of them is a substantive judgment. And it's one that was obscured in many of the cases, but came to be explicit in the fall in a decision, in an opinion Justice Kavanaugh wrote, when the Wisconsin case, a variation of the Wisconsin case, came up again. And namely that it's constitutional to run these elections under the procedures unmodified without the changes that were put into place. Namely that it's constitutional to force a voter like Jennifer Taft and Wisconsin voters generally to make this choice between risking their safety or not voting at all. That it's constitutional to refuse to count ballots cast after election day, cast before election day, received after election day, but postmarked before. That there's discretion in states within the state to decide what rules they're going to put in place. And to highlight the point, I guess I'll make what might seem like a far-fetched example, but just to drive it home. If a few days before an election, a state legislature were to say, only men get to vote, only people over 30 get to vote, there's no doubt that a federal court would come right in and say that's unconstitutional, and would say that regardless of how close to the election it is, regardless of the constraints of Article 2. And so too here, there's an implicit constitutional ruling in all of these cases. The Wisconsin case itself rested on a district court ruling, or the primary case, that that not extending the date, that allowing Wisconsin to run the election under unchanged rules presented an unconstitutional burden on the right to vote under the Anderson verdict balancing test. The lower court was explicit and the Supreme Court displaced that ruling. Along the way, we get dissenting votes, Justice Ginsburg in the spring, Justice Kagan in the fall, calling the rulings of the Supreme Court and other federal courts disenfranchisement. Justice Ginsburg called it massive disenfranchisement. Justice Kagan pointed out that the rulings would disenfranchise citizens by denying them their constitutional right to vote. And what the Supreme Court says, and other federal courts said as well in this litigation, was you're simply wrong about that. That your rhetoric is wrong, as the court said in the RNC versus DNC, entirely misplaced. No one's being disenfranchised. And what we're seeing in these cases is the majority of the court parting company with the dissenters on the and holding what are essentially fundamentally different conceptions of the right to vote. And I think much of the public has shares that divide as to what the vote involves. I think the per curiam in that earlier case and throughout the election season genuinely thought it was issuing a limited technical decision because the law has evolved so dramatically. And we have seen this predictable culmination, if you will, of a dozen or more years of decisions that have circumscribed the right to vote so dramatically. And that we see in the last election cycle, sort of a culmination of this new paradigm. And I'll press this issue and I'll try and close here. We can talk if anyone's interested or when I finish the paper about the specific cases in which we see this, this formal conception of the right to vote emerging. A conception in which having the bare legal ability to cast a ballot, no matter how difficult, no matter how fraught that process is, suffices for purposes of the Constitution, and everything else falls into this realm of discretion. And there was, and it's worth recalling, an earlier version that's found in a series of decisions that's found voiced by Congress when it extends the Voting Rights Act and the like, that envisioned or conceived of the right to vote as not just an abstract formal right to cast a ballot that's counted, but the actual ability to do so through procedures that treat voters equally, that it's functional and that was functional in orientation and sensitive to the burdens that might present unequally across different populations. I see I'm past my time, so I will stop there, and thank you again for being here, and thank you for including me in this.
Thanks so much. Professor Tolson.
Thank you, Heather. And also thanks to Kellye and AALS and LSAC for organizing this conference. It's really an honor to be here and on a panel with such terrific scholars. So my comments, I want to use the January 6th insurrection as a jumping off point for thinking through some of these issues of race and democracy. Shortly before the January 6th attack on the Capitol, President Trump gave a rousing speech to the crowd, right? He called them amazing patriots. He said that they must, quote, demand that Congress do the right thing and only count the electors who have been lawfully slated, end quote. Our country, he told them, quote, has been under siege for a long time, and you'll never take back our country with weakness. You have to show strength and you have to be strong, end quote. While it remains to be seen whether President Trump's words that day rise to the level of criminal incitement, it is beyond dispute that by casting doubt on the outcome of the election months before it occurred, he emboldened his supporters to take up arms to prevent Congress from certifying Joe Biden's clear victory. And by wrapping his lies in the cloak of patriotism, Trump fueled the view that a violent assault on the Capitol, which resulted in 5 people dead, was a legitimate action, similar to the actions of the American founders in 1776. In fact, the mob seemed to believe that the insurrection was their 1776 moment. Many returned home after the attack, expecting celebration of their actions rather than condemnation. Besides being a horrible bookend on the Trump presidency, the storming of the Capitol illustrates how the language of patriotism and revolution has been co-opted to excuse behavior that could be described as inciting an insurrection, or more pointedly, as a seditious attempt to undermine the peaceful transfer of power. Not coincidentally, the language of revolution reemerges when whites feel threatened by the rise of minority political power. For 7 weeks, the Trump campaign filed lawsuits in multiple states key to Joe Biden's victory, seeking to disenfranchise minority voters in urban centers like Philadelphia, Milwaukee, Atlanta, and Detroit based on specious claims of fraud. The Trump litigation and actions by some local officials on the ground called into question the legitimacy of the election and really a government in which voters of color play a central role. Resisting a free and fair election is not and never will be patriotic or revolutionary. But the efforts to overturn the 2020 election highlights the extent to which our commitment to democratic ideals, even in the face of a free and fair election, is highly racialized. No matter how much we commit to democracy as an ideal, there will always be some subset of white people who think that they have to, quote, take the country back when their preferences do not carry the day within the democratic system. In other words, democracy for me, but not for thee. Importantly, our commitment to democracy has always been racialized. No matter how much our rhetoric about being a democratic ideal for the world to follow would convince you otherwise, we forget that it is our love-hate relationship with democracy, rather than an absolute commitment to democratic ideals that is as American as apple pie. The insurrectionists hold out 1776 as an ideal for a reason. The revolution was a time in which colonists broke away from a foreign power and planted the seeds of the greatest democracy on earth. But an uprising in the French colony of Saint-Domingue, 15 years after the American Revolution, tested our commitment to democracy in a way that the French Revolution, which also occurred around the same time, did not. Unlike France, Saint-Domingue's revolution, which we now know as the Haitian Revolution, initially started out as a slave rebellion. Nonetheless, it shared the same common theme with the American Revolution that resonated with many in the founding generation: the desire to break away from a foreign power and establish a sovereign nation. In fact, prominent Federalists like Alexander Hamilton and Timothy Pickering saw these parallels and supported the rebellion throughout many of its iterations, with the forces of the rebellion's leader, Toussaint Louverture, battling France, Britain, and Spain at various points, all of which sought to gain or regain control of the colony. When the treasonous Benedict Arnold escaped across enemy lines during the Revolutionary War, the fact that he and other British troops were ejected from Guadeloupe by former slaves during the Revolution likely induced many smiles among the ranks of the Federalists. But support also came from official quarters. For example, President John Adams appointed Edward Stevens as Consul General to build diplomatic relations with Saint-Domingue. Unsurprisingly, Thomas Jefferson was not a fan of the uprising because slaves there overthrew a plantation system similar to that which had formed the backbone of the American South. In a letter to the Revolutionary War hero Marquis de Lafayette, then Secretary of State Jefferson voiced support for the French Revolution while warning that the French colonies, quote, will be lost if not more effectively secured. Indeed, no future efforts you can make will ever be able to reduce the Blacks, end quote. Jefferson worried more generally that the insurrection in the Caribbean, quote, has given a considerable impulse to the minds of the slaves in different parts of the US and could lead to violence on America's shores. Jefferson was not alone in this belief. In the early days of the Haitian Revolution, Southerners worried that the flame of sedition would spread northward. Jefferson and other slave owners were well aware of how the dramatic increase in the slave trade created the conditions ripe for revolution in the States. Enslaved Blacks in St. Domingue well outnumbered the whites on the island, which had also been true in South Carolina in 1780s. Other Southern states also had significant numbers of slaves, sometimes making up over 30% of their populations and generating similar fears of insurrection. In 1802, Napoleon Bonaparte, with support from both the Jefferson administration and Great Britain, sent troops to St. Domingue in an effort to retake the colony and reestablish slavery, even though the practice had been outlawed throughout the French colonies in 1794. While officially following a policy of neutrality, Jefferson imposed Toussaint Louverture's regime and curbed the trade with St. Domingue that had thrived during the Adams administration. However, his refusal to send resources and aid undermined French efforts to retake the island. While the French were able to capture Toussaint Louverture, their invasion failed and the island was renamed the Republic of Haiti in 1804. The new Haitian Constitution not only extended citizenship to all on its shores, but also, importantly, permanently outlawed slavery. As a Southerner and a slave owner, Jefferson's opposition to the Republic of Haiti, a majority Black nation of former slaves who wrestled control from white planters and rebuffed foreign superpowers, his opposition is not surprising, but it is a position that is hard to coherently defend given the mystique and reverence around the right of revolution and the clear parallels between the Haitian Revolution and our own. The formerly enslaved in St. Domingue exercised the right of revolution, just as the Americans and the French during their revolutions, to establish a community that will recognize and sanction their freedom. The prevailing sentiment among many in antebellum America that enslaved Blacks could not be a political community because they were not independent, nor the holders of rights, well, that was inapplicable here. The people in the new Republic of Haiti, including the formerly enslaved, free Black and mulatto or mixed communities, had cleared this bar time and time again, beating back armies from 3 different sovereign nations seeking to curb this freedom. It is clear that the problem for Jefferson and others was the emergence of a free Black state, which not only threatened to disrupt the plantation system in the American South, but also threatened the notions of white supremacy that were so key in maintaining that system. Haiti is a clear historical example of our tenuous relationship with democracy, of the fact that many Americans, like Thomas Jefferson before them, conceive of democracy as desirable when it produces outcomes preferred by white people. There's no amount of law, no level of transparency about our elections, no degree of freedom and fairness in our elections that can save us if enough people start to believe that our commitment to democracy can waver when Black and brown people exercise power in ways that are outcome determinative. So when we wondered why the Capitol was so poorly manned, despite the advance notice that there will be a huge rally on the 6th that could possibly turn violent. When we think about the fact that the insurrectionists were able to return home after storming the Capitol, when we consider that only hundreds have been arrested, even though thousands were present, while we sit with the fact that there have been no congressional hearings on this insurrection, while we marinate on the fact that elected officials still, after everything that happened, promote the conspiracy that the election was stolen, it is all an unfortunate reminder that for people of color in this country in particular, our democratic ideals have always been provisional rather than permanent. Thank you.
Thanks, Renita. Professor Greenfield.
Thank you. It's such an honor to be on this panel of such distinguished scholars doing such important work. I'm going to talk some about the connection between voting rights and corporations. And then you'd be forgiven to think that these 2 areas of the law have nothing to do with each other. But I think with the recent events have proven that they do have some relationship. Now, let me start by talking about the fact that in America in these days, voting rights and electoral power depend on money, as well as a ballot box. And this is a function of constitutional doctrine. Ever since Berkeley v. Vallejo from over 45 years ago, and to a lesser extent Citizens United, we know that the support from a rich person means more than a support from a poor person, because the rich person's support comes with money. And the current efforts to restrict voting rights across the country have to be seen in the context where in which that the electoral process that we have depends so much on money, because these current efforts to restrict voting rights, which disproportionately affect people of color, must be understood in a context in which the existing way we finance elections already put people of color at a disadvantage, as Professor Ross mentioned a few moments ago. In a political system that prioritizes and constitutionally protects money, this money disparity and this racial wealth gap will beget and cement political disparity. And this political disparity creates regulatory advantages for the moneyed classes, allowing them to build their wealth. As Dorothy Brown's excellent new book, The Whiteness of Wealth, so reminds us that this is the wealth cycle and the regulatory cycle built on each other. Now, what we've seen over the last couple of months, ironically, is that voting rights advocates have been using politicians' dependence on money as a pressure point against those voting rights restrictions. And they've been marshaling the fact that corporations do not want to be identified with as supportive of these restrictions. Now, and the reason why corporations have become the target of so much pressure, in part, is because there's not many other options. As we all know, restrictions on voting rights, by definition, do not have an easy political remedy. And judicial remedies these days depend on a judiciary, and particularly a Supreme Court, that seem to be disinterested in constitutionalizing the problems or seeing the problems as constitutional in nature. So, but money still matters in politics. And so in an ironic way, perhaps, drawing on corporations to support voting rights in Georgia and elsewhere makes total sense. They have leverage in the debate that the people hurt by these voting rights restrictions do not. Now, this is especially true in Georgia, because Georgia is one of the 29 states that allows corporations to contribute directly to candidates, something that's not true under federal law. Florida, too, by the way, allows corporations to donate directly to candidates. And one of the reasons why Coca-Cola and Delta Airlines were under such pressure recently is because both of those companies had directly contributed to Brian Kemp, the governor of Georgia, and to the Georgia legislator that was pushing the voting rights restrictions through the Georgia legislature. And because of this pressure, the corporations have responded, culminating in a big two-page ad or full-page ad in the New York Times in April, signed by 100 corporations and other individual corporate leaders, including Google, Amazon, General Motors, all decrying the efforts to restrict voting rights. Now, it's a sorry state of affairs that we find ourselves in America, that the mechanism to put pressure on politicians is corporate speech and money, but here we are. Now, what do we make of that? If that's diagnosis, what's the prognosis? What do we make of this? Now, the GOP has definitely pushed back, right? We've heard recently from Mitch McConnell, who has said that corporations should stay out of politics, which is sweet coming from him. He raised over $70 million in his most recent campaign, much of which from corporate, either corporate PACs or corporations themselves. Ted Cruz recently had an op-ed in the Wall Street Journal saying that he would no longer take corporate money, corporate PAC money. And he's saying the silent part out loud. Usually, a politician saying "I'm not going to take your money anymore" is not seen as punishment to the corporations, but it's only punishment to the corporations if the corporations are getting value for their money and contributions. So Ted Cruz sort of made that obvious. My colleague here at BC, Heather Cox Richardson, has said that she thinks that this is a significant break from the past, in which the implicit deal for several decades now is that the GOP's the implicit deal within the GOP was that the anti-regulatory efforts and the electoral efforts would be financed from corporate coffers and but operationalized at the polling place with social conservatives motivated with anti-government, anti-regulation, pro-religion, and rhetoric and racial dog whistles. Now, the problem, according to Richardson, is that Trump has said the racist part out loud, and it's more and more difficult for corporations to be seen, to be aligned with that. And perhaps ironically, corporations are more savvy about this than the public servants themselves. Corporations are more sensitive and attentive to the richness and the diversity of America than many politicians. Corporations have to look at the long term. They have to. They can't be explicitly xenophobic. And in fact, as the GOP pushes further to restrict voting rights, the separation between mainstream corporate America and the GOP will become more attenuated. In a world in which the GOP is de-diversifying, it separates them more from American business, which has to be much more attentive and sensitive to the diversity of America. So how do we build on this trend? Now, one thing that I think it's fair to say is that, I don't want to be sanguine about the interests of corporations. Corporations are certainly not acting altruistically; they're acting out of self-interest. But I do think that this is a trend that we can further, that we can nurture, in part by taking advantage of the market-based nature of corporations. The market, as we've known for a century, is a function of law, and we can and law has a hand in delineating the focus and obligations of corporations. Now, under current constitutional doctrine, wealth is translated into power in voting and elections. Under current corporate law doctrine, this power can be marshaled by corporations for the benefit of shareholders, mostly the financial and economic elite. But that's a product of law. I don't think Berkeley or Citizens United are going anywhere anytime soon, but I do think we could adjust corporate law doctrine to force corporations by adjusting fiduciary duty norms, by changing the decision-making structure, who's on the corporate board, to make corporations much more robust, much more diverse, much more pluralistic. So perhaps in an ironic way, one way to further democracy in America today is to make corporations more democratic. I'll stop there.
Thanks. Well, I will say, given that the theme of this conference is supposed to be shoring up the rule of law and democracy, this is a grim set of prognoses. So I'm going to try to pull the work together because you all actually are touching on a lot of similar themes. And I wonder if I just might start with just a general question for the panel that pulls from Ellen's observation about formalism and functional forms of power. Because I think that's, if there's a through line here, is what connects everything that you're describing. And so here's my first question really is to think a little bit as a group about how do we deal with that problem if we've traditionally looked to the rule of law to defend democracy. So just to put a pin in it, Bertrall, you were describing the ways in which the sort of new forms of white supremacy are taking place. We used to call things like that racial polarization, which had a sort of anodyne way of describing a set of institutional relationships that involve racially based voting. But it's not something the court's particularly good at recognizing or thinking about. And regardless of whether Congress passes something, it eventually is going to get to the court because of its duties to evaluate whether Congress has exceeded its power. And so I just want to ask you all, do you have any hope at all? I mean, Ken has just told us we should look to corporations, not courts, as at least a partial sort of hope for some democratic support. I'm just curious where you find, if you were sort of spending your philanthropic dollars, your time, where would you put your energies if we want to push forward? So maybe I'll start with Bertrall, but then open it up to everybody.
Yeah, thanks, Heather. And I apologize that the panel is kind of filled with such pessimism about perhaps the role of law. And I am quite pessimistic about the role of law, though I threw in those two little nuggets about what, Congress and how the court might be able to intervene. But I think realistically speaking, it will ultimately come, and the change will come, or the limits to the damage will come from the people themselves. And I do think that one of the things that I'm feeling cautiously optimistic about is the fact that we saw an extraordinarily jump in turnout this past election, and we saw a extraordinary diverse array of voters participating in this election. In Georgia being the prime example of this shift in terms of the demographic of those who are voting, both in the general election in November and in the turnoff and then the runoff election in January. And so what are the factors that are at play here? Well, it seems that there's a recognition by campaigns that the best means by which you secure votes and support is to actually engage with people on the ground, right? And so engaging in greater canvassing and mobilization efforts. But that, with respect to those infrequent and non-voters, that canvassing mobilization effort will require a level of engagement that is quite intense and requires that politicians and campaigns, in a sense, provide a sense of how they're serving the interests of those constituents that they are seeking to vote. Now, to the extent that these politicians are focusing on, white racial politics or racialized forms of politics, that could be quite damaging. We saw that both in campaigns in the past that were associated with former President Trump. But I think that there can be an important counter effects that groups can play both inside campaigns and outside campaigns with respect to bringing and engaging in a more racially inclusive message with respect to understanding our democracy today and what it could be tomorrow, to diminish that sense of threat associated with multiracialism that some members of the population may feel and experience, and try to bridge those partisan lines enough so that we are not divided on things that are existential to this country. And so that is kind of my ray of hope. And the fact that, the amount of money in politics is for the most part quite damaging, but here's the silver lining. That amount of money in politics allows for a degree of engagement on the ground that we might not see if there weren't this flow of money into the campaigning. And so I think that that is a mechanism. I don't have much hope that courts can intervene in a way that's particularly productive, or that this court will do so, but I think that things can happen outside of the legal processes in ways that can be productive for our democracy.
Fidina, I wonder if I could turn to you. Your work has always been in conversation with the past and the present and our history and the law. And I wonder how you're thinking about this moment right now.
Believe it or not, Heather, I am incredibly hopeful. I know that my comments suggest otherwise, but this is why I try to use a historical lens, in part because it shows that we've been here before. And in some ways, we've been worse off than we are now, right? I mean, the period following Reconstruction was a really dark period in our country's history, but we were able to get past it. It took a long time, but in part, we were able to get past it because of sacrifices made by everyday people to fight back. And, eventually in conjunction with legislative action in the courts, we were able to make significant progress on having more racial equality in voting. And so the history really does encourage me to keep my eyes on the prize. And I do think that there are efforts now to try to protect our democracy. So HR 1 and HR 4, which was the subject, HR 1 was the subject of the last panel, although HR 4 did come up. I do believe that Congress has significant authority to address some of the problems that we are having with our democracy now. Congress can't be the only solution. Just like legislation that focuses exclusively on race cannot be the only solution. I do think we have to have this partnership between a lot of the sort of race neutral measures you see in HR 1 in conjunction with a new coverage formula under HR 4. I think that'll move the ball forward significantly. But the reality, though, is that we are in conversation. We are still talking about ways to improve our democracy post 2020 election. There are still scholars doing good work around this, and there are still movements on the ground to try to increase awareness of these issues. So I am incredibly hopeful. But I do think understanding the past is a way of really trying
Oops, I think we lost Renita for a second, unless I'm the one who's lost here. No, I see everyone else moving. Okay. We just lost you for a second. You said you were just finishing up your remarks. You're saying about moving forward.
Yeah, so understanding the past is very important to prevent it from replicating or repeating itself. So yeah, I'm hopeful.
So Ellen, can I ask you a question? Because whenever I think about being on the lawyering chessboard, you're always the person who sort of is seen often so far down the line. I wonder how you think about what happens when either HR1 or HR4 or some of the solutions that are on the table hit the courts. What would you predict? What's their best defense? How would you frame that legislation?
So thanks. I guess in part I'll just agree with what both Bertrall and Renita have said. I think looking ahead is a multi-party, actor institutional focus to think beyond federal courts in terms of making progress. And so some of that's going to be voter mobilization and turnout. And as Renita's pointed out in her work consistently for a long time now, I think, and this goes to your question, the elections clause is a very promising way for Congress to move forward. And there's a lot Congress can do pursuant to that could protect lots. And you can't predict everything, but could make a lot of headway in countering some of the things we've seen state legislatures doing just in recent days even. You know very well the difficulties and the constitutional challenges that will be coming HR4 and beyond to the extent if congressional legislation comes and to the extent it reaches beyond federal elections to state procedures. We know what that looks like. And I don't, I'm less optimistic than Renita on that coming out in a good way. I guess I would add, and this is more of a dodge of the question, I suppose, and rather than writing the opinion, I can envision striking down some of that legislation. There are other actors too, and I'll just put into the discussion things we've done in Michigan here. In 2018, we amended the Constitution, our state constitution under Prop 3, adding absentee voting on demand, sort of very basic things, early voting, automatic voter registration, and procedures that passed with lots of support from the voters. And I believe made it easier for voters to cast ballots under very difficult circumstances in the last election. So I think there's, a meaningful role for state law as well as part of this, as I am aware, not answering your question, but that there is, there are places mobilizing the voters, using the election clause, bringing in state law. We can't envision every problem that's going to come up, but we can do a lot better in shoring up some of the problematic areas.
Excellent. So I'm going to ask you a question that is from Kathleen Morris, the great Kathleen Morris, which is in some ways about corporate regulation as well, which is Facebook and social media. Is not something you were talking about in this iteration of it, and I realize I'm cold calling you, which is completely unfair, but to the extent that you think that that is also part of the democratic project, what work is there to be done on that side of the aisle?
Yeah, I do feel like a little cold called, but
sorry about that.
It's fine. Well, maybe I'll back up and sort of talk, take the meta question, which is, that each of us as citizens and as human beings are as affected by the decisions of Facebook's oversight board as by the FEC, right? And so the interaction between the regulation world, the regulatory oversight of those big mega corporations, and our daily lives. I mean, that's a key area of should be a key area of attention here. And I don't really know. I know some people are saying that these big organizations become sort of quasi state actors if they get so big, and I'm unsure about what I think about that. I do think though that having these kinds of bipartisan boards, oversight boards, is probably a good thing. But I do want to go back, Heather, if I can, and answer your first question, which is, what are some things we can do. And I do think that given the restrictions on voting rights that we're seeing, having embedded in them their own immunity from political attack, we have to come up with some other way to put pressure on. And that's why I think these recent efforts to use corporations as a pressure point is fascinating to me. And I think because, especially for corporations that are public facing, that are consumer facing, they've got to be much more attentive to the American polity than a lot of politicians, for the reasons that my colleagues have set out. And I think increasingly corporate money is either sitting out or turning blue in some important respects. I just was looking at the Open Secrets numbers from 2020. That the top spending publicly traded corporation was Chevron. It spent about $6 million across all races in 2020. There were 13 unions that spent more than that. So oddly enough, Citizens United may have had, because it uncapped both union and corporate spending, may have had sort of a bluish effect over the last decade than a reddish effect, contrary to what many people thought at the time.
So I want to just maybe go back to the question that Bertrall began with. So for those who don't do election law, there's always sort of been this traditional divide between direct access to the ballot, the kinds of things that Ellen was talking about, and then partisan gerrymandering, where everyone can vote, but it's simply that, but the way that the districts are designed have real effects on power. And Bertrall gives us this, sort of evocative way of thinking about this puzzle that we've always had between partisanship and race. It often used to be, the kind of tale we would tell is that partisan claims got pushed into racial claims, and there were these strange alliances among parties because of the ways in which the Voting Rights Act was so much more robust than partisan gerrymandering protections, that's the hydraulics of it. I wonder what you all expect from the redistricting cycle that's coming up. What do you expect to see? And do you expect the Voting Rights Act, Section 2 of the Voting Rights Act, the one part of it that still remains of the old girl, will have an effect on it? And I'll just remind everyone in the audience, please feel free to send questions into the chat. So Bertrall, do you want to kick us off for that one?
Sure. Yeah, I think that this will be a really interesting cycle. The court has officially, took its hands off of the pedal, or just decided to absent itself from policing partisan gerrymandering at all. And so any sort of court challenges will have to go and feature race, either through the 14th Amendment or Section 2 of the Voting Rights Act. Now, what I expect to see with this next round of redistricting is in those states in which the state legislature still control districting, which is fewer and fewer each decade, which is promising, is pretty extreme forms of gerrymandering. And I expect that effort that we saw in North Carolina, that was at the core of the Rucho case, in which, they're trying to draw 11 out of 13 Republican districts. And the only reason why they drew 10 is they couldn't imagine a way to draw an 11th. And I think that, they're going to imagine all ways in which they could rig the system for partisan advantage. But I think that what they'll do, and one of the main tools by which they'll do so is rely a lot on race, right? Because I think the Republican Party has very much associated itself with white identity. And as a result, it will focus in many states on capturing as many majority minority white districts as it can, or drawing as many majority minority white districts as it can to capture them, and to draw as few majority minority districts as they can. So the classic of packing phenomenon will come into play. Now, the question is, will they be subject to any sort of restraint on the racial side, right? We don't have Section 5 that enforced a soft mandate that states, at least covered states, draw a proportionate number of majority minority districts. Will Section 2 be enforced in a way that subjects states to some sort of constraint with respect to the number of districts that they draw? Because you can imagine some scenarios in which, a state has 10 to 15 districts and minority voters are packed into 1 or 2, right? And drawing districts in that particular way. And so I don't have much hope that the court is going to re-intervene and maybe revive its partisan gerrymandering policing that it's never really done. But I'm also skeptical about what it's going to do under Section 2, right? I think Section 2 is under some pressure right now with the court having some skepticism of any legislation that has any sort of disparate impact type standard, even though Section 2 is not purely a disparate impact standard, but it might be close enough for the court to raise questions about it. And they'll focus on whether there's any sort of purpose or an intent to discriminate or use race in these particular instances. And to the extent that the states can, or the Republicans can rely on partisanship as their motivation, right? I think it might excuse them from any further interrogation from the courts. And so I fear that consequence, and I fear the result and how it might lead to a more extreme racialized form of politics over the next decade.
Ellen, I see you nodding. I'm curious what you think.
Well, I mean, I want to bring Fernita back in so I can channel her optimism, because I actually share Bertrall's pessimism on this one. I mean, this will be the first cycle that we're going through since the end of Section 5. The case law from the last decade on gerrymandering, racial gerrymandering cases, where we saw the deployment of claims the Voting Rights Act made us do it in, what one might characterize was quite a cynical fashion, giving way to not particularly productive results. So I don't see Section 2 being a real break on any of this. Guy Charles's work, I think, has explained this beautifully from the last decade on what's happened here. So I don't, and the ability to, I mean, and this is an old argument, claim partisanship rather than race as the motivating factor for the packing of minority voters into, fewer and fewer districts, I think insulates a lot of claims from the racial gerrymandering attack, either under the Constitution or under, a Section 2 type claim. So yeah, it's just unbridled pessimism there. And, we could compound that with the vulnerability of redistricting commissions, at least with regard to federal elections. We can all count votes with the precedent upholding that from six years ago, I guess now, 5-6 years ago. There's not, the justices that were part of that critical majority are not on the court anymore. So while we haven't heard from everyone, there's, an undeniable vulnerability of some of these institutions. It won't affect, I don't believe, their ability to affect state redistricting plans. So there's a ripple effect there, and maybe there's some optimism with regard to that. But if there's an expectation that the Voting Rights Act itself is going to provide a meaningful break on the excesses of either partisan gerrymandering or somehow increase minority representation, I'm looking at Fernita and hoping her she can cheer me up, but I don't see that happening.
Fernita, what do you think?
I was thinking about a presentation that Ellen gave a few years ago when we were at Ohio State, and it was about Shelby County. And Ellen, she said, I attempted to take the opinion seriously, but it was really hard for me. And I never forgot that, especially looking at a lot of the case law over the last decade, that you have to try to take it seriously, even when you understand really the court's goal is to try to remove any consideration of race and then make it a free for all when it comes to partisanship. And I think moving into the next decade, I do think that's why state law will become increasingly important in this area. So for that reason, I remain optimistic, right? Because state constitutions have free and fair election provisions. They have right to vote provisions that we can draw on. Josh Douglas has done some great work around this. And I also think that, litigants, with federal law, you have to be careful now in a way that maybe wasn't quite as true, but the writing has been on the wall for a while, right? Bertrall points out how with Section 2, it's under pressure. And so I think with Section 5 already gone, we have to look for different, AirPods, sorry. We have to look for different and more creative ways to try to protect minority interests in the next round of redistricting.
Ken, I want to ask you a question about the relation between race and partisanship in your domain, and then I want to turn to a Ned Foley question. But in a funny way, this corporation is sort of elite politics at some level, but also sort of attentiveness to consumer, which is more of a groundswell. It's really hard to imagine corporations doing this if it were partisan, right? If explicitly the Republican Party, the Democratic Party is doing something, and yet maybe a more positive sort of, maybe to be cheerful with Fernita, these racial questions have actually motivated them. The fact that there was so much racism behind much of what happened in the last few months of the elections process. I'm wondering just how you think about the relationship between those two things, given that the corporations do hold themselves out as nonpartisan, but are taking stances in a world where race and partisanship are just swirling together. Oh, and Kent, you're muted.
Sorry, I should know that by now. Yeah, such a fascinating phenomenon, right? Like, and I'm reminded a couple of things to sort of chop up here. First of all, this, in terms of having sort of popular pressure being born on, aimed at corporations, it only works if the corporation is consumer facing, right? If you're Coca-Cola, it makes sense to threaten a boycott or threaten a protest. But if you're some company that's doing non-consumer, if you're Boeing, I mean, how are we supposed to boycott Boeing, the consumers? And so, there's only limited access points here. But my colleague Heather Cox Richardson, when she was saying that for so many decades there was this implicit deal that the corporate mainstream would sort of populate or fund the GOP, but you couldn't say the racist stuff out loud. And the reason why you had such a break between the corporate world and Trump was because he started saying the racist stuff out loud. Now, I guess my main point, if I were to sort of summarize anything, is that we should seize this moment and try to nurture that separation. And the GOP is sort of dooming itself by focusing on these voting rights, which will make their own politicians less and less open to the views of the diversity of America, the pluralism of America, and in a moment where corporations are becoming much more and more attuned, and I do think corporations are being more willing to be open and focus on and not being partisan, being welcoming and being open on race grounds. I'm reminded of Coca-Cola's commercial in the 2017 Super Bowl at halftime. Right after Trump came in, the Muslim ban was just on tap, and Coca-Cola's halftime commercial was "America the Beautiful," being sung in all these different languages with all kinds of different people and singing it and focusing on all kinds of different families. And I think that's the kind of thing that we could engender and nurture.
So Ned had a really lovely question. Ned Foley had a really lovely question connecting a conversation in an earlier panel. So for those who weren't there was sort of a sentiment within that panel that it was important to separate out questions of vote counting and the legitimacy of the election and so on from other kinds of elections questions. And Ned's astute question, which I really particularly goes to Franita's statements, but I suspect all of you, was what is your view of that? Is that a mistake actually in terms of framing these issues? I'm letting you read the question. So I saw Bertrall. Oh. I'm gonna pop over to him first, and then I'll
sorry.
No.
Yeah, I mean, I don't separate them out insofar as we're seeing the targeting, as Ned mentions in his question, of minority urban centers that tend to have a high proportion of minority population. And what this harkens back to me is your earlier scholarship earlier on vote dilution, in the sense that when you diminish disparately confidence in election in certain places with a high number of minority voters, right, you in a sense can dilute their vote in this way. If you have this process that is more rigorous and scrutinizing of vote counting in certain places and not others, then that will almost inevitably often lead to certain voters being dismissed in certain places and not in other places. And if those votes get dismissed in certain places that tend to be higher proportion minority because those ballot counting processes are being scrutinized more closely than in other places that tend to be more white, that can have a harmful effect in terms of the value or the quantitative, the objective value of the vote in those places. And so also there's this other corresponding effect that I'm worried about too. To the extent that it becomes in our mind that there is Detroit, and we know in Detroit there are nefarious things that go on there, and we are more likely to be dismissive of the vote totals there. And we are often, we might be even sometimes tempted to take those vote totals out and think about how the election would look without Detroit. That has the effect of really diminishing the value and importance of the vote. And that can instill within the people of Detroit that our vote matters less, right? It may not count less in that election, but to the extent that we give a sense that their processes are inevitably corrupt, we give them the sense that, you know, we feel differently about your votes. And in the next election and future elections, that may diminish their willingness, Detroiters' willingness to vote and participate in elections. So that's what I worry about. And that's where I see them linked very much in important ways.
I agree. Oh, sorry, I didn't know.
Please go ahead. I was just going to.
I agree 100% with that. I think when you think about the harm, regardless if it's issues of access or aggregation or counting, the goal is to diminish the political power of minority communities. And so it's really important to think about it, I think cohesively, but I wonder if we have to take a different approach in terms of strategy. Because there are different lines of cases that govern the fundamental right to vote, separate and distinct from the right to vote free of racial discrimination, particularly in the court's case law. So I wonder if it's useful to think about them separately in order to avoid those areas of the court's case law that make it really difficult for plaintiffs to win these cases. And so you may get some purchase with that approach, but in terms of the harm, I agree that vote counting is something that we should think of as another dimension of this problem.
So Kent actually just popped himself into the queue and came up with a great question, which really goes for Nita to something that you were talking about early on. I know that Guy Charles has written extensively about it, which is about thinking about universal versions of voting rights and voting rights that are more targeted. This one is about regions. It's a federalism question in some senses, but do you think that Kent asks essentially what's understood to be the Manchin Compromise, which is applying a Section 5 to all states, would be constitutional?
I'm happy to jump in unless somebody else
Please
wants
go
to.
ahead. Perfect.
So I think it depends, right? So it is a federalism problem, and I actually think you made this point on the first panel about, sort of generalizing out preclearance could pose these federalism problems, and this is why HR 1 has some appeal. It's kind of the future of voting rights in this area because it's neutral and it doesn't have those same federalism problems because it applies to federal elections. But that being said, there are provisions in HR 4 that I think get around some of that. So there's a known practices provision that targets certain practices as opposed to certain geographic areas, where it is technically a pre-clearance sort of coverage formula for the entire United States, but it focuses on those practices that have been historically used to disenfranchise communities of color. So for example, when a state redistricts, they would have to get that pre-cleared. Voter ID laws, proof of citizenship requirements, when they refuse to circulate materials in certain languages, given that they have a large portion of minorities who speak that language for elections, ballots. These are practices that would have to be pre-clear, which I think avoids some of the problems you would have in having a coverage formula that applies nationwide. Instead, focus on the practices rather than the geographic entities.
Other views on the panel?
So I might just circle back, if I could, to combining, I guess, Ned's question a little bit as well. I think the recount question, not the recount question, the counting of ballots and the way that Detroit was targeted raises, sorry, this is not responsive to Kent's question, but I just want to add this. We haven't really used the tools that we have for conventional voting rights litigation, whether it's constitutional claims, whether it's right to vote claims, whether it's racial discrimination claims, and put that on what we might call the back end and sort of think about and sort of adding transparency and thinking about that process. What does a Section 2 claim look like if it were applied to the way a state is recounting is the wrong word, counting ballots and certifying the election? And we haven't really looked at that carefully. I think Bertrall's exactly right about the damage that is done at that juncture, and that we saw in this iteration more visibly than in my lifetime. I think that we've seen that happen, and it ties to what Freddie is just talking about too, in terms of how we understand whether it's the racial discrimination component, it's the right to vote component, and what it ends up looking like. could Congress do something to help, which I guess is a little bit more responsive to the more recent question in terms of thinking about that. We do need an accounting and a look into it. And I think one of the difficulties that we saw in Detroit in the days following the election, and many of my students reported this who were there, was the role of private individuals who were disrupting, who came in from other communities to disrupt the recount and to, lodge accusations of impropriety with very little foundation. That's not state action, and it's very difficult to understand how we deploy that. But it's certainly an area where I do think we need to sort of focus attention where we haven't previously done, because the last election shows a vulnerability, which gets back, I think, quite to many of the questions that were discussed this morning about voter confidence in the process. That post-election counting is obviously crucial to how we think about it and how we should deploy the tools that we have traditionally used for the casting of ballots, for voter ID, for districting and the like, to that process.
So I am sorry to say that we are right at 2:45. So I have to say, whether or not those in the audience are leaving here with pessimism about the future of voting rights and rule of law, I think you must have to have enormous optimism in a field that has such distinguished scholars inheriting the mantle of leadership. You all are amazing. It's so nice to be part of this conversation. It makes me miss my old job. So I just want to say thank you all for not just being on this panel, but for all the work that you've done that has brought you here. We're in your debt. Take care, everyone. Bye-bye.
Thank you.